Great.
So before I begin, I'd like to establish a system in which we can weigh today's ground, and that is that if the pro gives you net benefits in today's ground or an improvement upon the status quo, that's enough to affirm today's resolution, meaning that if we criminalize cyberbullying, if we can possibly reduce the incidences of cyberbullying in our society today, then that's why you affirm. Another observation I'd like to make is that every single point in today's ground that matters must be rooted in the real world. We need to conduct a real-world analysis of this topic, and with that, I'd like to pose a question. I challenge my opponents to give a single example where constitutionality has been breached in the real world in the states that have implemented cyberbullying criminalization. If they can't do that, they fail this real-world burden. Now we'll start at the top of the case. The first thing they tell you is that the statute is arbitrary. The first part of this first contention, they talk about violations are based on the victim, and I have two responses to this. The first is that that's absolutely fine. The violation can be based on the victim. For example, if I'm not bothered by somebody's cyberbullying, then I don't have to report it. But if somebody else is, that person can. That's how the law works, and that's not really a reason to negate today's resolution. But my second response is that even if you don't buy that last response, you can still vote for the affirmative, because what we see in today's round is that we criminalize the action that is intended to harm. For example, my partner gave the analogy of wearing a mask and then running around and shooting people. Sure, he may not have meant to kill somebody, but he did, and that's the action we criminalize. It's a problem in our society that needs a pro ballot. Now, the second part of this first contention, they talk about how over-criminalization is a big problem. And I have three responses to this point. The first is that, look, cyberbullying is a big problem in our society. We need a big solution to stop this big problem. The idea is you can cross-apply all the points we give you in our round. While in our case, we tell you that 1.5 times as likely to commit suicide, more alcohol in the drug use, and 1.5 point lowering of the GPA scale. Sure, we're not going to be criminalizing all Americans. We're going to be criminalizing the most extreme cases of cyberbullying that can be combated right now. So as long as you, again, any improvement on the status quo, that's a reason to affirm. But my second response is that this has no basis in the real world. I'd like for them to prove to you that right now, over-criminalization is occurring. It's solely hypothetical. And lastly, the simple idea that intrinsically all our benefits outweigh their point. I'd like to point out that in their last rebuttal, they failed to review the most important points of our case, the short-term and long-term relief provided by cyberbullying criminalization. In the short term, someone can call the police can come and provide short-term relief in the situation. In the long term, the tangible consequence point provides deterrence. According to the Cyberbullying Research Center, 47% of Americans believe that if there was a tangible consequence to their actions, they wouldn't be cyberbullying. A pro ballot achieves that, and then at the end of this, that's the end of their point. Let's go to the second end. They talk that criminalization bears on just consequences. The first part of this tells you that, look, it's false that you're just blocking discourse. The discourse has to have a purpose. As the Supreme Court ruled in Appleton versus Shirley quotes, it is not plausible to uphold the right to use words as projectiles where no exchange of views is involved. Unless they can prove that cyberbullying is actually productive and there's a clear exchange in views, it's not free speech that's protected. Free speech isn't an absolute right in today's round. Rather, it's a proportional one that can in fact be restricted, as the pros do. And at the end of this point, they talk about the chilling effect on free speech. That was my response to free speech. You cross-apply the same exact thing, but perhaps the most important response is this idea of the real-world analysis. Name one example where free speech has been infringed upon in the states we bring up. For example, Missouri, Idaho, and Kansas. These are states that have implemented criminalization well. Free speech was not infringed upon, and that's another reason to affirm. But then another point is, my opponents base their entire case on constitutionality. The Constitution itself is not a reason to negate today's resolution. For example, in the Constitution, an African American was considered 3/5 of a white man. That doesn't mean that was just. The purpose of us debating this is to really see if it is just. If what we're doing is just in today's round, since our whole case is predicated on that notion, you negate on that point. Now go to the final point. It's again the same free speech argument. They're just rephrasing this, and so you can cross-apply the same responses there. But in response to their vagueness point they bring up, the idea is laws don't have to be vague. We give you examples of specific legislation that isn't vague today. Idaho, Kansas, Missouri. They specifically define as having intent to coerce, harm, or other people, and the actual harm actually taking place. So remember that, look, it doesn't always have to be vague. They need to prove to you that point, which they simply don't. And so overall, in today's debate, remember that they dropped our short-term relief, long-term relief point. Those are our two biggest benefits in today's round, and I urge you to affirm.
What's the definition of cyberbullying Missouri uses in their law?
Right, the cyberbullying definition is having both the intent and...
Now, in Missouri, you said you want me to examine their law. What's the cyberbullying definition in Missouri?
That's what it is. It's repeated, severe...
No, it's harassment. It's harassment online. I have Missouri.
Actually, yeah, if you read the very last part of the case, which you obviously have, it said they extended this to people of juvenile sector. That's the point of cyberbullying. It was harassment, they extended it.
Yeah, it's just, that's all it is just harassment law, though. It doesn't fall under your definition.
They recently just extended it cyberbullying.
Has the Supreme Court ruled on these, has the Supreme Court ruled in any of these state statutes?
if you want to look at it, you can. And the overall idea we have to realize is, first of all, your entire case is based on constitutionality.
If you could answer my question, that'd be wonderful.
All right, my point is, name a single constitutional infringement right now.
Okay, well, for one, if you're gonna use your definition of cyberbullying and harm is in your definition, according to Dwyer v. Oceanport School District, the mere fact that a statement causes hurt feelings is not freedom of expression unprotected.
My question is, name a single example where constitutionality has been infringed upon when criminalization has occurred in the states that have implemented.
Okay, providing one example.
So you have no real-world analysis.
I mean, yeah, my real-world analysis is if you look at like the chilling effect for one.
All right, name where that's happened. Name one state.
One state where that's happened is in Saudi Arabia. You're much less likely. Okay, if my example is Saudi, maybe it's the United States. Okay, no, I mean, like, I don't understand why it's the U.S. specific. We're talking about free speech rights. And the reason why they're important, and the reason why a chilling effect exists. Look at Saudi Arabia. In Saudi Arabia, you don't even let me explain my Saudi Arabia example. So I see how you're going to respond to it. Okay, so my example in Saudi Arabia is that basically because they have much stringent punishments, more stringent punishments on free speech and less free speech protection, actually people are less likely to go out and speak out. So unless
that's absolutely about how we have different jurisdictions over Saudi Arabia.
Okay, but that just proves my free speech point, though. I mean, like, the point is about free speech.
Right? In the United States, can you give me a single
application?
In the United States, can you give me a single
Okay, you want to talk about, like, penalties?
Well, can you give me a U.S. example?
I'm going to ask you a question in like 8 times.
That'd be wonderful. Sure, you can.
Alright, so, I do not have a specific U.S. example. However, you have a specific... Yeah, okay, if I could please ask you a question. Alright, so you keep on saying, like, penalties are going to provide deterrence. Providing one example of a cyberbullying case that would have been deterred by your penalties.
Alright, two responses. The whole thing your whole like deterrence argument, those studies aren't based on specifically cyberbullying. Here's how I prove my benefits. My benefits are not solely deterrence like USU. You have to review the short-term benefits in terms of how people can call the police. The police can come and that investigation.
Why would people call the police? What makes you think people call the police? Why are schools? What did UNC say was the reason why? What did you not? What did University?
I understand.
Yeah, I haven't finished my question, but that's okay. You don't even know what the question's about. Because basically, according to UNC, the reason why the school punishments aren't effective is because kids are afraid to go to their parents or their school. Now you think they're going to go to the police?
Right now, if I can respond, according to the Iowa State study we brought up, right now people aren't going to the police because they see no law that can actually help them. The vote and pro does that.
But they don't even go to their school district or their parent. Aren't they much more comfortable with their parents?
Because there isn't any legislation that can help them now.
Yeah, but they don't need legislation. You got Tinker.
They fail.
Let's get to some of the main issues of today's voting. For one, definitions. What they're trying to do is they're trying to supplant all of our constitutional evidence. We've seen in Reno, which requires specificity. Dwyer specifically states that hurt feelings do not render speech unprotected. Brandenburg are protected even the most heinous speech, and Musser, where it has to be a very not a vague speech. Obviously, what they're trying to do is override all these by saying that the Constitution doesn't matter. What we have to see is that this is not a two-way, not a one-way street. We can't just have the Constitution doesn't matter because what we have is an infringement of our liberties. That's kind of the main point of our case. And for example, I'll give you the example of Emile Zola, which they have dropped so far in this round. For one, I can give you the example of how he vehemently and intended to harm public officials by using his newspaper a century ago to basically harass them into getting a treason conviction overturned. They have dropped this the entire round. What they're trying to do is try to show you a merit of cyberbullying. They said, we have to show you real-world merits of cyberbullying. If you were doing it online and overturn a treason conviction, you could go to jail for being a cyberbully. So obviously, we should show you how the definition vague is entirely vague. Let's talk about their point about how you have to deal with other statutes. For one, the Center for Safe and Responsible Internet Use, which they specifically cite, actually says convictions don't do anything because, for one, according to our Singer and McDowell study, for example, this simply increases recidivism because criminal sanctions, it specifically states criminal sanctions don't have an effect on the reduction of juvenile crime. Not to mention how they entirely fail to see why school sanctions don't work. Because, according to UNC Law School, people don't go to schools because they're afraid about school policy. What makes you think they'll go to the cops to try and get to talk to cops so they can't talk to their parents or schools? Obviously, they have no solvency for this, so their short-term, long-term relief point is entirely irrelevant. If we show you how the short-term point is entirely irrelevant, people won't call the cops, and the long-term point, which goes to the long-term remedy point of their, I guess it's sub-one, whatever, the contention, don't really have contention, specifically states that 5 points, like, what they're trying to say is that long-term relief essentially will be provided. What they fail to see is that under their vague and broad definition, 5.7 million American teens could become criminals. And what we also see is we have a 1.5% decrease in GPA. Tinker comes in. So what we have, one is a situation where schools can regulate it, two where you make millions of citizens criminals, three where you restrict free speech, thus the con is more just and we should win.